Director of the Public Law Program here at Duke, and it's a wonderful treat to be trying to manage a program that seeks to bring interesting topics and interesting people having to do with constitutional law, other public law issues to the law school on a regular basis. And we're starting off the fall semester on the very first day for the upper class people, and after a couple of days of legal research and writing, but the first substantive class day for the 1Ls, with a very interesting panel on signing statements. I'm not going to say more about that. I'm just going to put in a plug first for a week from today. Well, in this room, we'll be doing our annual Supreme Court preview with some of our local in-house constitutional law talent discussing the significant cases of last term and then previewing the significant cases for this term. So with that, let me turn the proceedings over to the moderator of today's panel, our own Professor Kurt Bradley, and he'll introduce the panelists and get us going.
Well, thanks everybody for coming to our panel session. As Professor Shroeder mentioned, it's on presidential signing statements, and you probably have heard about it in the news lately. What I thought I would do is just say a few words about what these documents are and about at least a little, give you a sense of some of the controversy that swirled around the Bush administration's use of these documents, particularly controversy during the last year. And then I'll just introduce our panelists today. So presidential signing statements are short documents that presidents sometimes issue when they sign a bill into law. And these statements often contain political rhetoric. They may thank the legislators for the bill, take credit for the bill, perhaps chastise legislators for not going far enough. But sometimes these statements will take a position about the meaning of the legislation that the president is signing into law, maybe to guide the executive branch, or maybe in the hope that courts would pay attention to the views of the president about the meaning of the law when it gets litigated. And sometimes these statements take constitutional positions about the bill that's being signed into law, expressing concerns, particularly about how the law may intrude upon the executive's constitutional authority. And the statements take a variety of positions in that instance. Sometimes they say the president will interpret the law narrowly in certain ways to avoid what the president maintains as a constitutional problem in the bill. Sometimes they say that they'll comply with this particular provision they think is constitutionally problematic, but only voluntarily as a matter of comedy, and they want to state on the record that they're not obligated to do so. But sometimes these statements even suggest or imply that the president will simply not enforce or not follow a particular statutory provision because the provision being signed into law is in fact unconstitutional. There have been these documents or these signing statements really since almost the very beginning of U.S. history, pretty occasionally and early in U.S. history, much more common in the 20th century, particularly after the New Deal. Notwithstanding the fact that we've seen these documents for a long time, there has been significant controversy, as I mentioned, about the Bush administration's use of signing statements. And I just thought I'd just say give you a few highlights about that controversy to give you a sense of what people have been talking about lately. So it may have started to some extent in December of 2005 when President Bush, at the end of that month, signed into law a statute called the Detainee Treatment Act. And the Detainee Treatment Act has a number of provisions, but one of the things that it does is that it purports to prohibit the U.S. government from subjecting anyone in its custody to cruel, inhuman, or degrading treatment or punishment. And that was, among other things, intended to apply to the various terror detainees being held, say, Guantanamo or other places in the world. And with some fanfare, the president signed that legislation into law, but at the same time issued a signing statement stating that he would construe this prohibition on treatment, quote, in a manner consistent with the constitutional authority of the president to supervise the unitary executive branch and as commander-in-chief. And some people construed that statement, although it's somewhat vague, as suggesting that the president was reserving some right not to comply with this prohibition on cruel treatment, at least under certain circumstances. And that became quite controversial. In April of 2006, the Boston Globe ran a very widely reported article claiming, quote, that Bush had quietly claimed the authority to disregard more than 750 laws enacted since he took office. And there have been many citations of that figure. The American Bar Association then came in and created a task force to look at the constitutionality and legality of these signing statements. And the task force reported recently that they had looked at this, and their conclusion was that presidents who issue statements claiming some authority to disregard allegedly unconstitutional laws were acting in violation of the rule of law and our separation of powers. And the ABA House of Delegates very recently approved almost all of that report, although it modified a few provisions to emphasize that it was condemning the misuse of signing statements. And finally, Senator Arlen Specter has had hearings already on the practice of signing statements in the Bush administration and has proposed legislation that, if enacted, would allegedly give Congress the ability to sue the president to challenge his positions in the signing statements. We have a very distinguished and knowledgeable set of panelists here today to talk about this topic. Most of them have already weighed in to some extent in some of the public debates that have been going on about this issue of signing statements. So in the order in which you'll hear from them today, first we have Eric Posner from University of Chicago Law School. He has written a number of books already on a variety of topics and numerous academic articles on issues relating to the war on terrorism, international law, and law and economics. Before entering academia, Professor Posner served, actually like all of our panelists, in the Justice Department's Office of Legal Counsel. All of them have had some service in that office. Eric and I recently wrote an op-ed piece in the Boston Globe taking issue with some of the views of the ABA on this issue, and he and I have been working on a longer journal article that tries to consider some of the institutional implications of these documents that the presidents have been issuing. Our second speaker is Trevor Morrison, an associate professor at Cornell Law School. Before entering academia, he clerked for Justice Ginsburg on the Supreme Court and also served, again, like all of our panelists, in the Office of Legal Counsel. And he's already written a number of important articles on constitutional law issues, including an article that's about to come out in the Columbia Law Review that considers whether it's appropriate for the executive branch to construe legislation in a way designed to avoid constitutional concerns, something that comes up in the signing statements debate. And last but certainly not least is our own Walter Dellinger. He has written extensively on constitutional law issues, presidential power issues, but he also has served for several years as the head of the Justice Department's Office of Legal Counsel in the Clinton administration, and also for a year as acting Solicitor General of the United States. And there are two memos, you may hear about them in the panel discussion, that were written by the Office of Legal Counsel in the 1990s that relate to signing statements and the President's authority to interpret the Constitution. Those memos are the most widely cited OLC memos in today's contemporary debate. Those memos were in fact authored signed by Professor Dellinger while he was head of the Office of Legal Counsel. And Professor Dellinger also recently wrote a very thoughtful op-ed piece in the New York Times taking issue with some of the American Bar Association task force views, and his op-ed piece has been very widely cited and discussed. So I've asked the panelists to get us started today, speaking for 10 or maybe a few more minutes than that, introducing some of the issues in the signing statements debate, and then I'll give them some opportunity to respond to each other's comments after that, and hopefully we'll have at least a few minutes at the end for your questions. Professor Posner.
Do you want me to come up there? Does that make sense? Or?
If you want to, sure.
Oh, okay. Thanks, Kurt. I'm multiply magnified here by the amplified here. I guess this works? Okay. So let me say a few words about signing statements. I don't want to repeat what Kurt said. So let me give you a little bit of the history. Signing statements go back almost to the founding of this country. They only became widely used in the 20th century, and particularly, I think it's probably accurate to say with FDR. And then another sort of inflection point would be Reagan. So FDR issued dozens and dozens of these signing statements, and so did Truman and Eisenhower and Kennedy and Johnson and Nixon. Many of these signing statements were just purely rhetorical, thanking Congress or criticizing Congress or what have you. But some of them took pretty strong constitutional positions. But it's really the Reagan administration that started using them more aggressively, issuing them more routinely. And as I think Kurt mentioned, for two basic purposes aside from the rhetorical or public relations purpose. One is to try to advance the president's own interpretation of a particular statute for reasons unrelated to the president's own constitutional prerogatives. So a statute might just be ambiguous, and the signing statement offers the president's interpretation of the statute as a kind of legislative history. Reagan's Attorney General Meese tried very hard and used some clever ways to try to get courts to pay attention to signing statements, so that if there was an ambiguous statute, the court might look at a signing statement the way that they routinely look at legislative reports, for example. It wasn't really very successful, though. Courts do occasionally look at signing statements, but I think there's probably been a total of maybe 20 circuit court opinions where signing statements are even mentioned. And in those opinions, usually the court says, well, the statute's ambiguous, the committee report says X, Y, Z. By the way, the president also says X, Y, Z, so X, Y, Z is the meaning of the statute. You didn't get the sense that the courts paid too much attention to the signing statements. Now, these signing statements were controversial, and there was a little bit of a media frenzy then as well as today. But the signing statements that people are upset about today are slightly different. They tend to advance the president's constitutional views about his own executive prerogatives. Now, again, this started with, well, this goes back many decades, but again, Reagan did this a lot, and then so did the first Bush, Clinton, and the second Bush. These signing statements, that you read them, they're interesting because in a lot of ways they just seem like form contracts. I mean, they're full of boilerplate. So a statute might say, well, you know, the president can appoint so-and-so, but he has to use the following criteria, or he has to select from this group of people. And the president will say, well, that violates my appointments power. Or Congress will say, you know, you can move the troops around, but you have to report back to us. And the president will say, well, that violates my commander-in-chief, it violates my powers under the commander-in-chief clause. Congress might say the president at some point has to propose legislation, and the president will say, well, that violates my power to recommend legislative measures to Congress. And that's pretty much what these signing statements look like. They're really uninteresting for the most part, in the same way that the boilerplate of form contracts are uninteresting. Now, another interesting fact about them is, and we'll probably go into this a bit, Clinton, who obviously is a Democratic president, he also took, at least compared to, I think, the general view of the legal academy, a fairly strong position about presidential powers. In fact, virtually all modern presidents have. And so his signing statements look a lot like the Bush signing statements. They make the same sort of boilerplate arguments. What's different when you compare Bush and Clinton systematically is simply the sheer quantity of challenges that Bush has made in his signing statements compared to Clinton. So, now again, we're referring to the actual number of challenges of statutory provisions, not the number of signing statements themselves. Bush hasn't issued any more signing statements than any other president going back to about Kennedy. It's always, for all these presidents, it's always about 20, 30, 40 a year. But what Bush has done, which is different, is that in any particular signing statement, he might challenge 10, 15, 20 provisions of the relevant statute, whereas Clinton would probably only challenge 1 or 2 or 3, and so on for the earlier presidents. Why? Now, there's an interesting question. Why is it different? I think the underlying assumption in the media debate and elsewhere is that Bush has taken an extreme position on executive powers compared to earlier presidents. Now, that might be so. I don't think the careful academic work has been done yet that would establish that. It is clear that, at least with respect to some of the provisions of the Constitution that presidents rely on, such as the Appointments Clause, Bush has taken a stronger view, but it's really not that different. In terms of the Commander-in-Chief Clause, which is a lot more controversial, I don't know whether one can say that Bush's views are strongly different from Clinton's. Part of the problem here is simply 9/11. With a national emergency, presidents traditionally will advance stronger views about their ability to command the troops, and it's hard to know how Clinton would have acted in similar circumstances. Let me briefly describe some of the normative issues surrounding this about signing statements and why there's a debate. So first of all, let me try to deal quickly with probably the least interesting part of the debate, which is whether signing statements are legal. That is, whether the president actually violates the law by issuing a signing statement in which he says that he's not going to enforce a statute because it violates his constitutional prerogatives, or he's going to interpret a provision in the statute narrowly in order to avoid constitutional problems. Now, the ABA task force report says that this is effectively a line item veto, and line item vetoes were declared unconstitutional by the Supreme Court a few years back. This is not a good argument because signing statements are not line item vetoes. Unlike a line item veto, a signing statement doesn't purport to just nullify a provision of the statute. And given that courts generally don't pay attention to signing statements, whereas courts always defer to vetoes, it seems odd to try to equate the two. What's really different about a signing statement is that the president just announces his views. Now, he might instruct his subordinates in the process of announcing his views about a statute, but the president has every right to instruct his subordinates to act in a manner that is consistent with his interpretation of the statute, as affected, for example, by his views about his constitutional powers. There's nothing illegal about that. Now, it could be illegal or unconstitutional for the subordinate to carry out an order not to enforce a law when the president doesn't have the constitutional authority to do that, but surprisingly, despite his 800-plus provisions, challenges of provisions in the Constitution, this simply hasn't come up. As far as I know, nobody has accused Bush of actually following through on a signing statement and refusing to enforce a statutory provision in a manner that's constitutionally problematic. It reminds me a bit, though, of a doctrine in contract law, which I teach, called the doctrine of anticipatory breach, right? So anticipatory breach, you haven't yet breached the contract in a literal sense, but you've said you will. And at that point, under contract law, it is deemed that a breach has occurred. So you can sort of understand the logic of the critics of the signing statement. It's as though the president has announced that he will, and once he has, he will violate or refuse to enforce a statute. And once he's made that announcement, we should treat him as though he's really done it. But I don't think that's what's really going on when the president says in a signing statement that he's going to interpret a statutory provision narrowly or as unenforceable in order to preserve his constitutional power. So what is going on? In my last few minutes, let me take a shot at explaining what's going on. So first of all, so the question is, why do the presidents do this? Why have they been doing it now for almost 200 years, and why have they been doing it rapidly, increasingly over the last 50 years? Well, the presidency has become a lot more powerful since the 19th century, and this is just a fact that everybody agrees has happened. Some people regret it, others celebrate it. The presidency is more powerful than it used to be, and the presidents have taken more seriously. Well, the presidents have advanced broader constitutional powers in the last 50 years than they have in the past because they think that's necessary and appropriate in order for them to be able to execute their duties in the modern world where the U.S. is no longer isolated from the rest of the world but is constantly interacting with it. Now Congress has acquiesced to this in some extent, but it has also resisted it. Congress is not terribly happy when the president says that he has more power than perhaps they understood in the past, but at the same time, Congress frequently delegates power to the president and has acquiesced, I think, effectively to many of the expansions of presidential power over the last 50 years. Why has Congress done this? Well, I think it might be that, as some people say, that it's lazy and it wants to avoid responsibility. I'm a bit more optimistic. I think the Congress just thinks that the presidency is a more effective office or institution than the Congress is, especially when dealing with foreign affairs. Be that as it may, this process by which the constitutional norms governing the relationship between the president and Congress have changed has not really been through what we normally expect, which is Supreme Court decisions. The Supreme Court intervenes every once in a while and says what it thinks these lines should be. But in fact, what's been going on for hundreds of years is that Congress has been advancing particular views about what congressional power is. The president has come back with particular views about what the president's power is. They fight it out, and Congress might threaten not to appropriate money if the president doesn't go along with its view, and the president might threaten to veto some projects that Congress wants if Congress doesn't acquiesce in its view. And this is really what's been going on. And the signing statement, it turns out, is just another way in which the president makes known to Congress what his views are about his constitutional powers. It's not the only way that the president makes these views known to Congress. He can also make speeches. He can issue statements when he vetoes legislation. He can write executive orders and memos and so on and so forth. There are lots of ways in which Congress and the president struggle over the right contours of presidential power. The signing statement is just one, and not a particularly interesting one, I think, as well. So we can, if you want to criticize the Bush administration, that's fine. But the reasons that you should give for criticizing the Bush administration is not that he issues too many signing statements or that he challenges too many laws in his signing statements. You have to actually do the hard work of reading the signing statements, which you're not going to learn a whole lot from, but really reading the OLC memoranda and the speeches and so on and so forth that Bush has issued and his predecessors have issued, and try to figure out whether his views of the Constitution are right or not. It's a substantive question, not a question about numbers or quantity. Now, this has been completely ignored by the media and the ABA task force, I think, which have taken a pretty simplistic views about what's going on here. Let me close with, Kurt wanted me to say something provocative, so I want to close with something provocative. Provocative usually means wrong and liable to destroy your reputation, but that's okay. It's also going to be provocative for our other panelists. I hope they'll tell me that I'm wrong. Okay, so if signing statements are as boring as I've tried to suggest, why has there been so much excitement? Well, I think it started with the media, right? And I think that the media simply misunderstood the phenomenon, which is not surprising. The media misunderstands lots of things. Not just journalists who report what the Bush administration has been doing, but sort of non-lawyer op-ed writers who sort of jumped on these reports and said, here's another reason for thinking the Bush administration is horrible. All right, that's not very interesting either. But what is more interesting is the reaction of the lawyers once they became involved in the blogosphere and in the opinion pages and elsewhere. And I think there's an interesting phenomenon here. So this is a theory. It's a kind of a Freudian theory about what's been going on in the blogosphere. I think that when Clinton was president, liberals, people with liberal views, Democrats, were happy, of course. And liberal lawyers wanted jobs in the Clinton administration. They ended up in the Justice Department and especially in the OLC, which is terrific. That's good. The OLC, though, is super duper, this is a technical legal term, it's super duper pro-executive, and it always has been. It's an office in the executive branch, and it's always taken extreme views, at least relative to the academic consensus, if there is one, about the extent of the president's power under the Constitution. Now, many liberal lawyers are fine with this, so I'm not going to single out any particular person, but I think most liberal lawyers who ended up in the OLC were probably a little bit uneasy about the super-duper, the traditional super-duper pro-executive jurisprudence of the OLC. So they felt a little bit uneasy, but they had to go along with it, because that's what the OLC does. It basically, I hate to put it this way, but it basically provides a legal basis for the actions that the president really wants to take. It might sometimes tell him he can't do something, but usually it doesn't. Okay, so these lawyers could, on the margins, provide better arguments than other people did, or try to push the president back on certain things. But basically, they had to go along with it. Okay, that's fine. Now Bush becomes president. Bush takes extremely strong positions about executive power. And as I mentioned before, this has become more complicated post 9/11, where presidents traditionally, after emergencies, do take stronger positions on executive power. I think now the liberal lawyers who worked for Clinton feel guilty because they feel like they've provided part of the basis for the extreme views that the Bush Justice Department, Bush OLC, and Bush himself, to the extent he's paying attention to these things, have advanced. All right, so that's my theory, and I think a lot of the reason why this has gotten so much attention in the blogosphere and among lawyers is that they're a little worried, and Kurt and I have gotten a kind of a frequent reaction to our paper, which is you're really just defending the Bush administration, aren't you? Bush has taken really extreme positions and Clinton has not. And in fact, we don't. We're not trying to defend the Bush administration or criticize the Clinton administration, but we think that their views about executive power are not as different as many people have suggested. And I think the signing statement is kind of the frenzy about it reflects, I think, to a certain extent, the conflicted feelings of a lot of people who've been involved in both the Clinton and the Bush administration. And with that, I will yield to the people who actually know about this rather than speculate.
Thank you. Professor Morrison.
Thanks. It's a pleasure to be here to join you. I think it's a great idea to put this panel together. I expected many things of this panel. One of them was not to be psychoanalyzed by Eric Posner. So let me just offer some comments a little bit out of order and a quick reaction to the psychoanalysis, and then to dig into my theory on why so much controversy has attended this president's use of signing statements, given the fact that, as Eric quite rightly says, this is not the first president to use signing statements at all. It's not the first president to use them in the general way that this president has used them. It's not the first president to use signing statements to resist potential legislative incursions on executive prerogatives. So what's all the fuss? Well, I think it might be this. It's true that in order to object to any particular signing statement, one does have to do the hard work, I agree with Eric there too, of figuring out sort of the substantive contours of the law on that particular issue. When one does that, not just in the signing statement area, but in other areas of what we might call executive branch legal practice in this administration, I think one of the things that does distinguish this administration somewhat, not categorically, but somewhat from those that went before, is a willingness not just to assert very robust executive prerogatives in areas where Congress has not acted, that is sort of aggressive presidential authority in a kind of vacuum, but a willingness to go an additional step and to suggest that legislative restrictions, even that don't count as absolute prohibitions, but legislative restrictions on the way the president might exercise certain of his authorities are simply invalid. Now, the signing statement context is not the best sort of area to which one would point. The sort of exhibit A for that attitude is the Office of Legal Counsel's initial torture memorandum, I think, which suggested that a categorical statute barring the use of torture and other aggressive forms of interrogation, the OLC torture memo suggested that that might just be, in fact would be, simply unconstitutional to the extent it would prohibit the use of those techniques if directed by the president in his capacity as commander-in-chief. Now, as robust as liberal OLC staffers might be as to executive prerogatives, I don't think that any suggestion, comparable suggestion, had ever been made by OLC or really anyone in the executive branch. Certainly, I'm not aware of one. And there are other examples like that as well. The Justice Department's defense of the NSA's warrantless wiretapping program has similar features to it about the real inability, potentially, of Congress to restrict action in this area if directed by the president pursuant to his commander-in-chief authority. The problem with those sorts of episodes, though, is that you almost never know about them, right? The story on these things is broken years after the offending document is written. And the one thing that signing statements have going for them is they're public. And so I think this is a kind of redirection of frustration. There's a suspicion on the part of liberal law professors, if you want, former staffers of OLC and heads of OLC, but I think others as well, that one thing that does distinguish this administration from others is that very aggressive assertion of presidential authority, even to overwhelm legislative restrictions on that authority. And to the extent one sees sort of echoes or faint shadows of that approach in signing statements, then the public kind of seizes on that because at least that's a public statement of this view. And one wonders if that's a kind of tip of the iceberg and what else the administration is doing that we don't know about. Are there other memos like the torture memos that we still haven't heard about? So that's my, I don't know, Jungian analysis, if the former was Freudian. Now, maybe one way I could frame sort of the main part of my remarks is to build off of what Eric said. He said there are sort of two controversial ways in which signing statements might be used. And one is interpretively, in the face of an ambiguous statute, to create a kind of presidential version of legislative history and to say, this is how I would construe the ambiguity in the statute. And the other is, to interpose some kind of constitutional objection, right? This statute might intrude on my commander-in-chief authority, and to the extent it might, I will construe it not to do that. Or the statute does intrude on that, this provision of it, and so I will just not enforce that provision. For me, signing statements, especially like President Bush's signing statement accompanying the McCain amendment, sort of combine these through the use of the canon of constitutional avoidance. And that's what that recent article, or forthcoming article of mine that Kurt mentioned, tries to look at. So the canon of constitutional avoidance is a tool for interpreting statutes, figuring out what otherwise facially ambiguous statutes mean. And the canon says that when a statute can be read in either of two ways, A and B, if A, say, is the otherwise preferred reading, if it would raise serious constitutional concerns, whether or not it would actually be unconstitutional, as long as it would raise serious constitutional concerns, then we ought to prefer B. So this is an interpretive device on the one hand, right? But it's also a way of interposing a constitutional objection, at least to a potential reading of the statute. I think it's at least possible to read the president's signing statement accompanying the McCain amendment as a kind of loose invocation of the avoidance canon. And so what I want to address is, well, is it legitimate for the executive branch to use the avoidance canon? So this is, and I'm going to suggest the answer is maybe. Sometimes, but we have to be worried about certain kinds of misuses. And so in that vein, I agree with Eric too, that the real question is not categorically signing statements okay or not. The question is more sort of as applied, particular uses of signing statements in particular ways, legitimate or not. So this avoidance canon, as I suggested, actually has two forms. What former colleague of Eric's, Adrian Vermeulen, has called classical and modern avoidance. Classical avoidance says, well, if reading A would actually be unconstitutional, if we know it would be unconstitutional, we ought to go with reading B. Modern avoidance says, well, even if it would just raise a serious constitutional concern, we ought to avoid that reading and go with B. The courts use the modern form of the canon all the time. They call it a cardinal principle of statutory construction. And it appears all the time, too, in executive branch legal interpretations. Across administrations, lots of opinions with Walter's name at the bottom use the avoidance canon. A few of them after his time. I helped draft use them. Lots of them from other administrations, too. But there's very little examination of whether this makes any sense. Why do we use the avoidance canon? What are the values underlying the avoidance canon? Is it, in fact, a complete case for the executive use of this canon to say that courts do it all the time? Eric and Kurt's new article, or at least the draft of it that I read, seems to suggest that it's perfectly fine for the executive branch to use it. With their indulgence, I'll quote one sentence from their article. They say, the Supreme Court regularly applies a constitutional avoidance canon when it construes statutes, and it's not clear why the president should not have a similar ability when engaged in statutory construction. Well, I think it's not clear that he should have that authority either. We have to ask the question, right? We have to ask, what are we doing when we use the avoidance canon? What are the values, or what's the theory underlying the canon? And what can we say about the particular interpretive context in which the canon might be used? And would our answers to those questions lead us to conclude that even if it's fine for the courts to use the canon, maybe not for the executive branch? Well, consider the values underlying the canon first. I think there are really two potential accounts of the canon. The conventional one I call the judicial restraint theory. And in particular, this applies to the move from that classical version of the avoidance canon to the modern. Right? So under classical avoidance, statute could mean either A or B. It's facially ambiguous. A, the court says, would be unconstitutional, so we go with B. Well, in the early 20th century, the Supreme Court said, we're worried about using that form of the canon because we think it would produce an advisory opinion, and that courts can't provide. And the thinking was something like this. Well, look, the statute's ambiguous. We use our other tools of construction, and we say A looks like the best reading. But then we conclude A is unconstitutional. And having concluded that, we say the statute doesn't mean that at all, and we go with B. Well, then everything that preceded going with B, the court was concerned, seemed to smack of being an advisory opinion. Now, today, I think we would not say technically that's an advisory opinion, but to the extent that that was sort of the thinking underlying the move to modern avoidance, a concern about advisory opinions and their illegitimacy, and then later, Justice Brandeis, in a famous concurring opinion in Ashwander, just sort of linked up this canon to concerns about judicial restraint and not intruding on the legislature generally. To the extent that's the thinking, it would seem to apply only to the courts, right? If that's the theory for avoidance, well, then why is the executive branch using it at all? Everything the Office of Legal Counsel does is an advisory opinion, and there's no problem with that. There is, however, I think, an alternative theory available to justify modern avoidance, and that's what I call the constitutional enforcement theory. And the idea here is that really the avoidance canon functions as a kind of resistance norm. That term is from Ernie Young at Texas, who's got an article on this point. And the idea is that the avoidance canon provides a means of enforcing the underlying constitutional norm, but not in the regular way of enforcing constitutional norms by invalidating statutes, just by making it harder for Congress to come close to a constitutional limit. And it's akin in this way to clear statement rules, which are other rules of statutory construction that courts and executive actors use in other contexts. That is, it's not that we're saying Congress can't say B, or say A rather, but it has to spend the political and other capital entailed in making clear that its intention to say B before the interpreter will conclude that that's what it's done. So it's a means of sort of softly enforcing constitutional values. If that's the theory underlying the avoidance canon, then I think it probably does apply just as well in the executive branch as in the courts. So we have a choice here, right? The dominant theory says avoidance canon shouldn't be used at all in the executive branch in signing statements or otherwise. The constitutional enforcement theory says, well, perhaps it can be. What one would like is more careful consideration of which theory the executive branch is going to go with before it so frequently invokes the avoidance canon in signing statements and in other areas. Now, let's suppose we adopt the constitutional enforcement theory. Well, as a general matter, that would provide, as I've suggested, a legitimate theoretical basis for the executive branch using the avoidance canon. However, we might be concerned, especially in areas like the McCain Amendment, that we might be concerned about abuse, that the executive branch will invoke the avoidance canon just to dodge legislative restrictions on its own power. And this might appear to us to be a kind of self-dealing. Certainly it's institutional self-protection, right? It would be one thing for the president through OLC or in a signing statement or otherwise to narrow a statute to guard First Amendment values. Because then what the avoidance canon is doing is really narrowing the reach of the statute itself. It's restricting governmental power. But it's quite another thing to use avoidance in a context like the McCain Amendment, because then what the president is doing is just broadening his own authority, at least potentially, relative to the restrictions of the statute. So Jeff Powell of this law school and others have suggested that because of that risk of abuse, that the avoidance canon ought to be deemed just categorically illegitimate, at least in areas where the result of it would be to enhance executive power. I don't take that view. I think that some degree of institutional self-protection is the whole idea of the separation of powers in our constitutional system. The Madisonian sort of vision of separation of powers is each branch taking care of its own prerogatives to some extent, ambition being made to check ambition, as Madison said. On the other hand, though, I do think that in self-protective circumstances, like the McCain Amendment, we have to be very worried about abuses of the canon. That is, executive branch uses of the avoidance canon to enhance executive power in circumstances where the avoidance canon, even on its own terms, really shouldn't apply. And that brings me to the other governing consideration I think we need to think about, which is interpretive context. My point here is that unless one is going to be a really hardcore literalist textualist, and no one in the executive branch really is as a matter of institutional policy, well, unless one is going to take that position, then one has to recognize that executive branch statutory interpretation often happens in a much more information-rich environment than does judicial statutory interpretation. Executive actors are often intimately involved in the drafting and negotiating behind a statute. So they know about statutory purpose, about design, about intent, in a way that courts do not. Statutory interpretation is not a matter of looking at a cold record from an arm's length. It's a matter of reflecting on direct institutional experience. Why is that significant in this context? Well, this avoidance canon is only supposed to apply when a statute is legitimately ambiguous. And to a court, a statute might appear facially ambiguous. But to the executive branch, that ambiguity might sort of melt away in light of what they know, given their direct involvement with the drafting of the statute. What they know was the purpose behind the statute. That, I think, is the case for the McCain Amendment. The president, it's true, it's not entirely clear what to make on the face of it, of his signing statement, which basically says, I will construe this statute to be consistent with my prerogatives as commander-in-chief. What does that mean exactly? But it seems fairly clear that it means that he means to reserve some authority to direct the precise activities that the language of the statute would seem to preclude. That is, the use of certain cruel and inhuman and other forms of interrogation near torture. And so the question then is, well, did the executive branch have a legitimate basis for believing that was Congress's intent? Because after all, this is supposed to be an interpretive exercise, right? The avoidance canon is supposed to give us a means of interpreting what the statute means. Or did the executive branch know full well that to the extent Congress had an intent or the statute bespoke a purpose, that the purpose of that statute was to be more categorical? Well, from what we know of the drafting history of the McCain Amendment, I think the latter is quite clearly the case. There was a long fight between the executive branch and Congress over whether the McCain Amendment would ever become law. The reason there was that long fight is because Senator McCain and the other sponsors of the legislation intended for it to enact a categorical prohibition on the use of these forms of interrogation, and Vice President Cheney and others wanted no part of that. And ultimately, a deal was kind of brokered because in the same legislation, basically, there were provisions seemingly severely restricting judicial review of executive actions in Guantanamo Bay and others. So this was a kind of compromise piece of legislation with lots of components to it. But that compromise did not entail any weakening of the resolve of the congressional sponsors of the legislation as to whether its ban on uses of these forms of interrogation was categorical or not. It was categorical and complete. In that circumstance, given the fact that executive branch leaders were involved in the negotiations and knew that that was the underlying thinking behind the McCain Amendment, I think it just cannot credibly be claimed that interpreting the statute to reserve some exception for the president to overcome, or that reading the statute to reserve some sort of exception can actually be called an interpretation of the statute at all. It's a rewriting of the statute. And so for me, that's a sort of classic case of abuse of the avoidance canon. And then in one small case study, an example of how even if signing statements as a general matter are legitimate, and even if the use of the avoidance canon as a general matter is legitimate in signing statements, we have to be very worried about how the canon might be abused in particular circumstances, used in the absence of genuine statutory ambiguity given the information available to the executive branch. That's what I think went on with the president's signing of the McCain Amendment and the accompanying signing statement.
Thank you, Professor Morrison. Professor Dellinger.
Let me
Yeah, it sounded worse than it was.
let me respond principally to Eric. I thought Trevor's remarks were excellent, and Eric Posner's arguments were almost always excellent, but where they fell short, they fell deeply and profoundly short of excellence. And Eric, I would put it this way. Let's assume that I agreed with you about all of the following. That we fully agree that the ABA was well off the mark in thinking there was something wrong with presidential signing statements. Let's agree that presidents have the authority to decline to execute statutes that in the president's view are unconstitutional. That the Clinton era OLC took, and I was very proud to take, a position of continuity with the assertions of executive power that had gone before. And let's assume even that, and I will defend each of these propositions from our perspective as to why we so fundamentally agree with the position taken by President Bush with respect to signing statements and its consistency with their own. And let's even say that if there are 750 signing statements that the president has issued, that we would agree with or have issued 746 of them, okay? That sounds like a lot of agreement. It's the other 4. I'm serious, it's the other 4. It's not a matter of quantity. It's the other 4, and not necessarily technically signing statements, but the assertions and the torture memorandum. It's the other 4 that are everything. It's the other 4 that strike me as a very deeply problematic assertion of presidential authority to act lawlessly by refusing to comply with acts of Congress that I would have thought were clearly constitutional in their constraints. One minor emendation on what Trevor said. It's not that the president sometimes asserts executive authority to refuse to comply with statutes, even where those statutes are intended to limit presidential authority. There are many instances in which we strongly believe that the president had the authority to disregard express and clear limitations on his authority. Many of those tended to be what those outside of the OLC fraternity would consider technical, that is, appointments clause issues, on which we are, I think, largely in agreement, on which I certainly was considered an executive power person. I don't believe that Congress can tell the president who the president can appoint or limit the field that from which a president may choose appointments. Just on the power to make appointments, that sort of use of the president's office. We really stand almost shoulder to shoulder on those, and I am in tension with some of the folks that worked at OLC with whom I've continued to debate these issues, some of whom Stuart may know are continuing to write about these issues and think that Congress can legislate the kind of criteria or qualifications that they think a certain office ought to have in the head of the office. But let me give an example. There's a statute on the books that says that the president may not name, that you're ineligible to be Secretary of Defense if in the preceding 10 years you have served in the uniformed military services. A laudable objective to maintain civilian control. I think it's just flatly unconstitutional. I just believe that categorically the president can nominate whomever he wishes and the Senate can vote the person down. But they can't jump over and tell the president who he can't nominate. And that accounts for a whole list of agreements that we have on the ability of the president to disregard acts of Congress. And when I criticized some of the substantive positions taken by the president, I was met with the what I thought was almost a virtually strange objection that I had asserted the power of the president to disregard acts that are unconstitutional. So now I was criticizing President Bush for doing just that, which misses the point that there is a vast difference between refusing to enforce laws that are unconstitutional and refusing to enforce laws that are perfectly constitutional. That is a big difference. And it requires the exercise of a substantive judgment, the kind of judgment that the ABA was unwilling to meet. And so let me, before going back and defending presidential authority, let me say, as a generic matter, where I think this administration has gone profoundly wrong in its assertions of the president's constitutional authority. They have done so by conflating a phrase, inherent authority of the president, that has two different meanings and two different settings. There is the question of what authority a president has when Congress has been silent and there's no legislation that restricts the president's ability. Does the president have the authority as commander-in-chief? Does he have the authority to carry out the war powers? Does he have the authority under many of his other heads of powers to do X when there's no authorization for him to do X in statutes. I am a very strong believer in fairly sweeping presidential inherent authority to act in areas of his responsibility in the absence of any legislation on the subject. I would be hard-pressed, to use a technical term, to find that a presidential action was what corporate lawyers would call ultra vires, sort of beyond the authorized authority of the president to do. So, for example, had Congress never acted, a president as commander-in-chief surely could establish a system for disciplining members of the military forces who serve under his command and do a whole elaborate procedure to punish them and lock them up and penalize them. That is an inherent authority the president has. This administration has, in the torture memo and elsewhere, assumed that if the president could do that in the absence of congressional silence, then, of course, Congress can't touch what the president has done. And that is a fundamentally different area. Congress, of course, can pass the Uniform Code of Military Justice and has had some equivalent of it for more than 200 years. And the president would have to comply with the provisions of the Uniform Code of Military Justice unless the restrictions on presidential power fit into a very small category of interfering with the president's ability to carry out the essential functions of his office in a very profound way. So there's a large category of power that the president can exercise until Congress has acted. Once Congress has acted under one of its legitimate heads of authority, like the authority to regulate the Army, to make rules and regulations for the conduct of the military forces, that to me is all presumptively a constitutional constraint on the president, unless it runs afoul either one of the technical, I think, notions that a president has the appointment authority. He can nominate his horse to be Secretary of Defense, and it's up to the Senate to vote his horse down, but not to try to tell him who he should nominate or from what categories, in my view. And so I am way out there with the tradition of executive power of the heads of OLC that were Rehnquist and Scalia, Bill Barr, Ted Olson, and others. But aside from that, there are very few instances where what Congress has done cannot legitimately constrain the president. And the sweeping assertion of presidential authority to disregard acts of Congress and the frightening conflation that comes when the defenders of that will cite the fact that President Washington engaged in this kind of activity, President Roosevelt engaged in this kind of activity, President Johnson engaged in this kind of activity, so it's clearly within the inherent power of the president. Well, the answer is all of those presidents did that before this activity was made a federal crime by the United States Congress. And that is a fundamental difference. And it's not the case that if the president has done it, you can't make it criminal. So that is my, the disagreement is huge with respect to the fact that the administration could issue an opinion on the torture memo that doesn't cite the Steele seizure case, that doesn't seem to recognize the authority of Congress to place restrictions, and that the administration will assert a freedom to disregard acts of Congress without making any showing that those acts actually interfere with the president's ability to act. In a debate, assuming I'm speaking hypothetically, but in a mock court I did with Ken Starr out at an earlier ABA meeting, I wanted to make the point that the Foreign Intelligence Surveillance Act authorizes foreign intelligence surveillance. It doesn't prohibit it. The president's been lucky in his selection of critics because often people will come in from the Fourth Amendment point of view. The president can't wiretap his no inherent authority. We shouldn't be wiretapping. I think we should be doing it. I think it's a good idea. I think presidents have done it. But there are, but you could make an argument that I did as a court participant in the ABA that when Congress says, here's the procedures you have to follow to do it, that those are lawful unless and until you make a very strong showing to the contrary. And I'm aware of no such showing except a general assertion of authority not to have to comply with the law. Worse yet is we're not going to tell you when we're not complying with the law. Because it may be unconstitutional for Congress to say, tell us when you think the law is unconstitutional, not going to comply. We're not going to tell you that either. And the sweep of some of the assertions of authority that we will apply the law only consists with the president's role as commander-in-chief, et cetera, such vague formulations that it's just a general assertion that we may or may not comply with the law. And that, to me, is quite different from the underlying issue. And I think with that, I have a vigorous defense on the other side of President's authority to decline to enforce laws that are unconstitutional. And think that I'm quite surprised that the general public seems to think that interpreting the Constitution is the exclusive province of the courts, and are quite horrified that presidents can engage in it too. And the public is quite skeptical that presidents could ever do so with any integrity, though they assume the courts, as the ABA says expressly, the courts are disinterested and apolitical, the president is political, interested, biased, et cetera. I think that dichotomy is hard to sustain, that if you believe that there is integrity in the law, and I've seen Republican administrations, which I was not a part, take very tough stands against the political interests of the administration to hold that it was unconstitutional, it would be unconstitutional for the president to index capital gains for inflation. They've taken, under the previous administration, there were a number of steps where they took very, very tough views. So rather than claim purity for myself, I have seen the integrity of executive branch lawmaking done and believe in it. And therefore, I think it is very important for a president to have that authority. I'd like to open it up for discussion.
Thank you, Walter. And let's thank all the panelists for their really interesting presentations. We'll have time for, I think, just a couple of questions, but I wanted to see if Eric wanted a brief statement there at the end.
Yes, okay, a couple of things. First of all, I think that Walter is quite wrong when he says that we disagree. I think we agree about everything. We agree that that what matters is the substance in any given case. We agree entirely, though, about the question of whether the president has the authority not to enforce laws that he legitimately and I think correctly believes are unconstitutional. And we agree that, and I agree with you, Walter, you're going to learn this if you haven't already. You can say nice things about the Bush administration without being a partisan defender of the Bush administration. And in this particular case, I simply don't, I suspect that we agree or don't disagree much about the four cases that you've mentioned, but I may be wrong about that. But in any event, I think the key point is the institution of the signing statement. That's fine. We, Walter and everybody else, and I and everybody else probably disagree about some of the substantive issues, no doubt. And that's important, but it's not really what the signing statement debate is about. And I think so the conflation is this, that people who say that there's something particularly wrong about Bush's substantive views here and here and here, there's a difference between saying that and saying that the institution of the signing statement is defective in some way. That's why Bush's defenders will refer to Johnson and Nixon and his other great presidents. Okay, Trevor, I wanted to disagree with Trevor as well, although not in this paradoxical fashion of really agreeing with him. I'll second what Walter said. There's not really a difference between categorical interpretations and interpretations by degree. The Clinton OLC was very strong, for example, on the commander-in-chief clause when it said, and tell me if I've got this wrong, but I believe that it said, this wasn't in a signing statement, it was in a memo, that Congress could not forbid the president to place American troops under foreign authority during the Bosnia crisis. Is that right? Yeah. I thought that was right. I think that...
and somewhat controversial within the ranks of OLC.
Okay.
That was where I was out there a bit, right, Stuart, on my own.
Okay. Well, I think you got it right, Walter. But I don't think it's that unusual. There are other commander-in-chief opinions from all administrations which make similar sorts of arguments. And then I just had, on the constitutional avoidance canon, I may not have understood your argument completely, Trevor, but it seems to me that the president has to apply the constitutional avoidance canon just because of just because of Chevron, basically. That if the president is trying to interpret a statute, or not even Chevron, just because when the president is trying to interpret a statute, he has to make a prediction about how the Supreme Court will interpret the statute, if it's likely that the statute will ever be, that the dispute will ever be reviewed by the Supreme Court, which is what happens frequently. Since the courts apply the constitutional avoidance canon, the president, he's got to do it as well, because if he doesn't, then at least to some extent, he's going to end up interpreting a statute in a manner that a court might reject. So it seems to me that if he wants to be responsible, at least, and avoid unnecessary litigation, he's got to use the constitutional avoidance canon. And finally, I want to say another provocative thing. This time about your criticism of the Bush administration's signing statement for the McCain Amendment. I just don't agree with you. It seems to me that if the Bush administration says, okay, here's the McCain Amendment, by the way, we're not going to pay attention to it to the extent that it conflicts with the president's commander-in-chief powers, that doesn't tell us anything. You know, we simply don't, there's no such thing as the statute which is perfectly clear in all future applications. He knows, the president knows that there might be future applications where this statute could come up, which was simply not discussed or anticipated by Congress or by the executive branch in its discussions in Congress. This is a sense, I think, that invoking the commander-in-chief clause is simply boilerplate. It's true even if he doesn't invoke it in the signing statement. It may turn out, you might be right that he's thinking, you know, this will be my chance later on, I'm going to violate the statute and then invoke the signing statement, but we just don't know that. It may be that he's just being careful. And one thing you can say about the Bush administration here is that it's very consistent. If a statute touches on the military, what the military does or might do, the Bush administration is going to cite the commander-in-chief clause and say that we're not going to interpret this statute in a manner that infringes on the president's commander-in-chief powers.
Trevor, I'm going to give you a brief response, and we'll end with that. And if people have questions, maybe you could just mill out after Trevor gives his response. Trevor.
So to continue the love fest, let me agree a little bit with Eric before maybe disagreeing a bit. I take Walter's sort of amendment to my point about what might distinguish this administration from others, sort of the robustness of its view of inherent and therefore unilateral executive power. At the same time as I agree with Eric that yes, that OLC under Walter and at other points in Democratic administrations has certainly asserted very aggressively executive prerogative. So I guess I want my point to be one of degree more than one of categorical difference, and that may bring us closer together. As to the McCain Amendment, how to read it, I agree there too. I write about this example in the paper, and I think at some point I just fudge it by saying, well, you know, given what we know about what went on in the drafting of this thing, you know, unless it really just was sort of thoughtlessly inserted as boilerplate, this seems to be a shot across somebody's bow, and in what way could that shot be consistent with the spirit of the McCain Amendment itself? But I take the point that it might be that all the president was saying was, well, any statute to the extent it would be unconstitutional is something that I can decline to enforce. So I'm not saying any single application this ever would be, but FYI. And I don't think that it's very likely that that's what the president was trying to say, but it's true one has to read between the lines to figure that out. Just one last point here that I want to sound a note of real agreement with Walter and I think with Eric on this point. One has to look again at the sort of substance underlying particular uses of signing statements. For me in particular, when some constitutional problem is being avoided by the president's preferred reading. But let me also say then that sort of brings with it a reason to be particularly concerned again about the use of the avoidance canon in this context, right? Especially the modern avoidance canon. It would be one thing if the president very publicly sort of admitted what his constitutional view was, right? This is the extent of presidential power that I think there is. This is what Congress cannot prohibit me from doing. At least then you've got open government. What the modern avoidance canon allows the executive branch to do is not to have to answer that question. Simply to say, well, there would be a constitutional concern if the statute were read this way. And therefore, we're going to pretend that Congress didn't mean it at all, right? That's much less politically costly, at least potentially, because the president hasn't said the statute is unconstitutional because it violates my vision of presidential power, and therefore I will regard that provision as unenforceable. And so that's one sort of another version of what one might call the sort of risk of abuse with the modern avoidance canon. The president doesn't have to say nearly as much about the contours of his authority. Now, admittedly, in advance in a signing statement, sometimes that's hard for the president to do. You need a concrete application of a statute before you can come to ground. So this is a criticism maybe better leveled at OLC opinions than at signing statements. But it is, at least for me, another reason to think really hard and carefully, and if I can say immodestly, harder and more carefully than OLC to date has about what role the avoidance canon legitimately has in any act of executive branch legal interpretation.
Great. And thanks again to the panelists and to all of you for coming.
Here's an example, an important example. What do you think about this? Avoidance seems very important